Today we're going to be talking about privacy requests. My name is Caroline Carver and I'm a principal consultant at Three Black Cats. So first and foremost, let us get started with talking about the basics of privacy requests and what it means. So privacy requests are an option under the Privacy Act for individuals to get a copy of their information or to request a correction of their information. Today we're going to be talking about getting a copy in the main. Now, if we were in Europe, quite often these are referred to DSAR requests, which stands just for Data Subject Access Requests. New Zealand, privacy requests, privacy information requests are usually some common words you might see for them. So, when we think about privacy requests, first and foremost, we need to think back to basics about why we have them in our legislation, because this will guide how we behave in terms of individuals. So the reason we have them in legislation, and by the way, they've been there since the beginning, and they are in nearly every other piece of legislation for privacy around the world. So they were originally put in around building transparency. So letting people see what information we hold about them so that they can then decide, do they want to correct it, or maybe they just want to see what we've got so that they can ensure we're not over collecting, etc. So that's really important. They might want to check the accuracy of our information so that we can get that corrected up. And it's also about putting the power back into the individual's hands so that they can feel like they are in control of their information. So they know who it's gone to, etc. Now, why are we talking about them today? They are something that doesn't occur in private sector very often. If you are getting a lot of privacy requests in private sector organisations, that quite often means there's something not quite right about your privacy settings in general. Maybe people think you're being overly collecty, a bit creepy. They're not happy with how you're handling something like a complaint about something non-privacy related. Usually is a good thing. However, we're going to have changes in New Zealand come May next year, where you're going to have to give a privacy statement to individuals if you collect their information indirectly. So if you get it from someone other than the person it's about, then you're going to have to give a privacy statement. I am well expecting that that will in turn lead to an increase in privacy requests. And the reason for that is if, say, my information has been shared with a vendor as part of going to a conference, I want to know now, what did they tell the vendor, right? I'm now invested. Did they tell them just my name and my company? Or did they tell them my name, company, dietary requirements, home address, and my credit card number? That's quite different. So maybe I want to make a privacy request to find out what they have about me. And then I might want to have a debate with them about why. Okay. So it's really important before May that your privacy request process is checked and make sure it is robust, because as I say, it is going to come up more and more come May. So who can make a privacy request? So privacy requests can be made by a couple of kinds of individual. So they can be made by the person themselves. So that could be a minor, it could be an adult, it could be male, female, any other, doesn't matter. As long as it's about them, they can request it. It can also be requested by the parents or guardians of a child. Now, this is one you need to be very cautious of. How do you confirm that the parent or guardian has the right legal authority to have a copy of that information? Or are you going to put that child at risk? So if you think about a child with two birth parents. They have separated and mother has taken the child into shine care due to domestic violence. The last thing you want is your organisation releasing the home address of that child if there is something like a protection order in place, or if you know there is domestic violence, etc. So we'll talk a bit more about how do we confirm that later. Some pieces of legislation, Health Act being one, have specific provisions about parents and guardians getting access to information about children. So make sure you check your own legislation if you are a government entity. Now, the other group we get is people who are acting on the authority of the individual. So this is quite often a lawyer, an advocate, for example, or if we take a family situation, it might be, say, a husband and wife. Okay, so in this case, the person with the authority is stepping into the shoes of the individual the personal information is about. Again, we want to be very, very cautious that they actually have the right authority and that the impacted individual, so the person whose information it is aware of what's going on. So some common ways we can handle some of these things. So for children, we might be asking for things like, can you show me evidence of parenting order? We might be saying, can you confirm, or can I speak to the other parent to confirm they're okay with this access, etc. So just thinking about how do you do it. And again, it depends on the sensitivity of the information you're going to release as to how careful you need to be about that. If it is an individual acting on behalf, usually quite a lot of organisations have a signed form that individual signs to say, I am acting for them. This is my tax agent accountant, for example. Again, there is nothing stopping you calling the individual and going, hey, can I just check that this is actually something you authorised? So give you an example of that. In banking last year, we had a whole range of privacy requests from a company, which all looked a bit weird and looked very much like they were there to create fraud. So when they all said they had the authority of the individual, but when we're actually contacting the individuals concerned, they had no idea what was going on. So really important in that case that we did check the authority to make sure that they knew about it. Equally, if you're going to release something super sensitive to that individual, you might want to confirm with the person, the individual concerned, that they understand that will be released. So, for example, if you are going to release someone's information about, I know, their financial situation, for example, or a medical condition, and it's quite sensitive. So maybe we're going to say, hey, did you know they tested positive for HIV? You maybe want to check with the individual concerned that they understand that that is going to be given to their agent. Okay. If they authorize it and you are fully happy that they are cognizant in their means, fine, that is their choice at the end of the day. Their personal information can be given to who they want. Completely their choice. So, how do we make these privacy requests? So, some organisations have online forms that you make this request through. If you get loads of them, strongly suggest an online form. Some people say send us an email. Some people have it go into the contact centre. Some organisations do not tell you how to, and actually just calling out that is a requirement in your privacy statement or notice that you tell people how they can request this. So you do need a method. Other organisations write to you, and it is up to the individual concerned if they want to write to you on pink sparkling unicorn paper to get their privacy request. then that is their choice. Okay, you can try and filter them into a set tool, but if they are absolutely adamant, then we can't force them. And again, that's horses for courses, right? In terms of what's appropriate for you. If you are the organization who is getting, 100 a month, your system for handling these will need to be very different to an organization who's never got one or has got like one in their lifetime. Okay. Any private sector organization who's getting more than about 3 or 4 a month, generally you'd want to look at what's going on and why you're getting so many, because there's something you are doing that is triggering these. So how do we respond? So first and foremost, acknowledge you actually have received the request. Okay. So that is a, hey, thank you for your request. We've received it on this day. We will come back to you in due course. There is nothing more frustrating for an individual to be like, I don't know if it's been received. I don't know if they've got it. I don't know if they're doing anything. And that is when they will then potentially think about going to complain to the Privacy Commissioner. We're saying sticking your head in the sand and ignoring them does not make them go away. Okay, so if you don't respond within the time frame, the person has the right to go and complain to the Privacy Commissioner. It is deemed a breach of the Privacy Act for you not to respond in a timely fashion. Okay, so it is something the Privacy Commissioner can come after you for, and can absolutely come with a compliance notice or some other enforcement idea around it. So what happens once you have acknowledged it? So you've got to respond within 20 working days. Now, working is a key word here. Some days are not working days. So Christmas Day, Boxing Day, etc. There is a handy calculator on the Privacy Commissioner's website to work out what 20 working days based on legislation is from the request date. So I would highly recommend you go and check the date that you need to respond by and make sure you're keeping an eye on it, because it will catch up with you really quickly. Now, if you cannot respond within 20 working days, there are reasons we can ask for an extension. And that extension, there is no set time limit on what it can be, other than it needs to be reasonable. Okay, so if I had asked for every copy of every email I have ever sent as an employee, and I kid you not, this is a request I have seen multiple times now, there will be thousands of them, right? 10,000, 20,000 that we're going to need to find, review, redact, etc. We are not going to get that done in 20 working days. So at that point, we could, once we've realized, oh my God, there's that many emails, we can advise we're going to need an extension. We might also need an extension because we need to consult with people widely about making a decision. Now, that consultation might be, we need to get legal opinion, external. We need to talk to the person's doctor on one of the grounds for redaction. That is not just, we're too busy to organise our own internal staff and this isn't a priority for us. The last one is that the request is so complicated that it's going to take us a while to work through it. Now, as you will see, all of these extensions are needed to be applied in good faith. So you need to have actually tried and actually be attempting to work to that 20 working days. There is not one down there that says, I'm too busy, can't be asked, etc. Okay, so we need to really be trying on it. And that comes back to that, why do we have privacy requests? Okay, it's about adding transparency. It's about letting people control their data. So if we sit on their requests for ages, then that's not going to help us or them. If you have a really complicated request as well, it is where we're saying you can go back and confirm the scope. So that is one way of definitely getting down the size of the request. So if someone comes to you, the common first answer is, I would like a copy of all personal information you hold about me. And we go, that's a lot of info. So usually at that point, I would send an email back saying, hey, I would like to confirm your scope. We hold the following kinds of information. Which of these are you sort of looking for? Do you want a copy of your bill? Do you want your notes from ringing our contact center? Do you want all emails we sent you, etc.? So it's like a shopping list of choices. Or you might say to them, are you only interested in a set time frame? Okay, I want all emails about me, but only for the last month. Okay, well, now that's become manageable and I can deal with that versus it being since time began. Okay, so you are welcome to go back to them and confirm the scope. If they are still adamant the scope is everything forever, then that is the scope and you're going to have to deal with it. Okay, but absolutely there is the opportunity to politely go back and say, can we clarify what you're looking for? Some people who get a lot of these in those online forms or request forms that they have quite often have that pre-done shopping list of choices so that they don't have to take that first step. So they might say, what are you wanting? Tick the boxes next to it. Please put the date range in. That way you don't have to take that extra step. So we've got our request, we've clarified our scope, and we've worked out our 20 working days. Okay, we now know what we're up to. In terms of what team deals with these is a common question. And that is usually either the privacy officer themselves, or it might be a team within your organization who solely deal with these and potentially official information requests as well, quite often the same team. Okay, well, it can be one or the other. And that's where it's saying, if you've got a question as we go through this, feel free to click on the Q&A and add them in to the conversation there. So yeah, if we've got it, it's now sitting with our team. So we look at it a bit more and we realize, actually, this isn't information we actually even have. Okay, so they have written to Department of Internal Affairs, for example, to ask about their immigration information. Okay, well, that's not something Department of Internal Affairs have. That's something Immigration or MB have. So we can transfer the request to MB. So we can transfer this request in whole or in part. So we might say, actually, we'll keep half of this request ourselves because they also ask for information about their citizenship, which is DIA. So we'll keep that bit and we will transfer part of it over to MB. So if we know who it needs to go to, then we can do that transfer. So that's usually government department to government department. If you were, for example, a telco and they come to you and you look them up and you're like, you're not a customer of ours, there is no expectation you try and work out who they are a customer of. It's just straight, we can't do this. Okay, but if we know that we ported them out and we ported them to Spark, for example, then we should transfer it to Spark. Okay, so when we're doing transfers, so if we have established that we cannot answer part of this request, it's not us, then we need to transfer it. And that's within 10 working days, we do the transfer. Or we can tell the individual, hey, it's not us, we suggest you go to this organization. Most people will just transfer it for them, telling the individual about it as it happens. The other reason we get transfers a lot outside of government is for vendors. So if I write to Microsoft and I say, hey, Microsoft, can I have a copy of all the information you have about me? They will likely come back and go, cool, can you confirm the scope of what you want? And it'd be like, yep, I would like all information that is held by, I don't know, organization A, where you provide their email and their OneDrive and their SharePoint and everything else. At that point, because that vendor is holding the information on behalf of that agency, it is not their privacy request to reply to. They are, in their own right, they are holding nothing about me. So in that case, they would transfer you to agency A or organization A, and the request can be done there. Or they might reply and say, we don't have anything. You will need to, if it's about stuff that we hold as a service provider for someone, you will need to contact them. Okay, so that's the other avenue we occasionally see those transfers. So we've worked out it's ours. We've acknowledged we've got it. Now what do we do next? So we need to think about, do we want to charge for it? So private sector agencies have the ability to raise a reasonable charge. We're saying there are some specific guidelines about health agencies, which could be private sector agencies as well. So please do check those if you are that kind of agency. But if you are a private sector agency, so a company, something like that, then you can absolutely charge for it. However, the charge needs to be reasonable. And the individual who's made the request can go to the Privacy Commissioner to complain about the charge you're proposing to levy on them. So it is quite common, for example, maybe, let's see, one organisation that charges $50 for a photo of our CCTV. Okay, took us a while to find it. We had to go through a whole lot of footage. That's quite reasonable. There are other cases, for example, where a law firm tried to charge many thousands of dollars to give someone a copy of a USB stick with their files on it that just needed dragging and dropping from one file to another. Not reasonable. Okay, so reasonable charges are set or advised, should we say, by the Ministry of Justice's guidelines. And these guidelines, by the way, are available on the Privacy Commissioner's website. So if you are thinking about charging, this is the way to go. So generally, first hour is free. After that, $38 per half an hour of staff time to deal with it. Photocopying, first 20 pages is free, 20 cents per page after that. However, you need to think about why individuals are making privacy requests, to think about, is charging appropriate for you? So if you are already having a stoush with the individual about something customer service related, and they're already upset and they've made a privacy request so they can see all the correspondence backwards and forwards, so they can see what everyone said, likelihood of you wanting to charge them is very low. You're just going to upset them even more than they already were. Okay, so do think about context of, do you want to charge? Charging can, however, play a place in terms of getting people to reduce their scope. Can be quite helpful. We'll happily do this for you, etc. But it will be 10, 100 hours of our time. It will be this much. Do you still want it? Okay. So thinking about how do you want to charge. The other thing is, think about your organization, and do you even have the capacity to charge, right? If you are going to want to raise an invoice for $38 for your organization, most probably you're going to have to set this person up as a supplier, then get an invoice issued, etc. Then when they don't pay, chase them up, and then make sure you know that they have paid. That's a lot of work for $38. It must cost you way more than $38 to do that work. Okay, so do think about how you use that charging appropriately. there is also some expectations around if you charge. If you charge, there is an expectation you are going to release the information and not refuse it. Okay, kind of goes without saying. If I pay for it, I'm going to get it. You also cannot charge for time spent transferring your request to a different agency. So time for me thinking about, should I send it to MB and whatever time it takes me to do it. Nor can you charge for the time spent reviewing the information to determine if we're going to redact any of it. So we can spend the time, we can charge for collating it, finding it all, searching for it at Iron Mountain, having to get the box back, all of that stuff, but not the physical act of going through it and working out what to redact. Okay, so just be very cautious about it. My strong recommendation personally is don't charge. If you are getting a huge number and you're thinking charging is your way out, I would be reviewing why you were getting a huge number instead of trying to charge people for it. Someone's asked a question. If we get a request on a date and then we contact them and ask them to clarify, or we ask to charge, when do the clocks go and stop? So general rule of thumb, if you're waiting on them, you can stop the clock. So if they made a request and it took them 19 days to confirm the scope, you haven't just got 1 day to do it. Okay, so it's 20 days for you to do your bit while they're not holding you up. Okay, so if it takes, I don't know, 5 days for them to confirm their identity to a level you're happy with, cool, then your 20 starts at that point. And we're saying you're charging if they don't pay for it. You set them a timeline. After that timeline, if it's not paid, you can close it, close, not paid. For all of this stuff, though, keep a really good record of what has happened on what date, etc. So that if it does come up for questioning, you've got a really good record of all the steps you took for it. Perfect. So, person's paid, or we've decided not to charge them, hopefully, and we've now collated all their information. The time-consuming part then comes to, well, we don't want to release all of it, we want to redact some of it. Now, first and foremost is consider why we do privacy requests. The idea is to add transparency and let people manage their own data. So that should be the driving force behind thinking about redactions. Okay, so the idea is not to see if you can redact the whole page. That is not the goal. The goal is to have the least redactions on the page possible. So what are some of the grounds for redaction? We're not going to go through them all. We'll just go through some of the most common ones. So the redaction would involve, not could, would involve the disclosure of something about someone else. Okay, so commonly it might be it's an email trail about 3 people. When I ask for my personal information, I should only be getting mine. You can redact out all the other people in it and the combined story. So if it was maybe, let me think, an email about an event that happened at work and it's talking about 3 people's circumstances, I would only get my section of it. Okay. We might also redact things like who dealt with your queries, maybe their surname or their first name, their email address, because that's not personal to the person who requested it. Okay, they're only allowed their personal information, not everything about everyone. Okay. When we though consider redacting it, we need to consider if the person we're redacting's privacy rights override my interests of having that information. So one of the key things we get is people are like, oh, I want to redact it, but the person already knows about it. Okay, so if we think about a medical setting, if I have been to see a specialist and I had an appointment and I know their name and I know their email address and their contact number because I booked the appointment, it is really pointless redacting that information because I already know it. Okay. Therefore, it's not going to be a breach of the doctor's privacy interest because I already know it. In contrast, though, if I don't know their mobile phone number, I only know their main switchboard number, maybe we want to redact just their mobile number. Okay. What helps with having less redactions for unwanted disclosure of another person's affairs is to keep your records really clean. So by that, I mean, if you want to send an email about 3 people, send 3 emails, 1 per topic, 1 per person. Don't intermingle them unless there is a real need to do so. And again, things like contact center records, etc. Make sure you've got the records on the right person's file, because that quite often comes up. Give me a copy of all the notes about me, and then we have to redact out a section of notes when someone wrote it on the wrong customer's file. Okay. So, next one. It's going to prejudice the physical or mental health of the individual. Okay, of the individual, not of anyone else, of the individual. Okay, now the key words in this one are it's likely to prejudice their health. Okay, so this might be if we release the information that this person's requested, we believe on good basis that they are going to commit suicide, or it is going to give them a mental break. Cool, that is the ground we're looking for. However, that ground has an additional piece which says that you have discussed it with a medical practitioner and they believe there is a real risk to damage to releasing it. Okay, so it's not just that your organization woke up and thought this was a bad idea, but your organization thought it was a bad idea and got medical advice on it and they confirmed it was a bad idea. Okay, so usual use case for this being used will be a health agency of some description. Quite often, it is usually not many other organizations around it. Serious threat to health and safety. Now, this is health and safety of the individual concerned who made the request or someone else. Okay, so if we release their information, we believe that they could, on reasonable grounds, come and kill somebody or really, really severely injure them. Now, this needs to be a serious threat. So I'm going to call you up is not serious grounds for my life, health or safety. I'm going to show up with an axe and kill you. That's serious. But there must also be some evidence that this threat exists. So I think this person might do it is not enough. This person has put in writing, if you said this about me, I will come and kill you. And then they proceed to do that. And that's what's in the release that we need to make, then that might well be happening. Okay. Equally, you might review your stuff and go, actually, they have a real history of getting very aggressive when we release information to them, and they have previously assaulted 3 staff members in our stores, for example. Okay, we might want to think a bit about this one. Okay. So just thinking about that, it's not just that it could, we need to actually have some pretty hard evidence that it's going to occur. More common one, harassment. So by releasing the information, somebody is going to have significant likelihood of being harassed. Okay, and harass being repeated and unwanted contact. Okay, so they're not physically harming them, they're just being super goddamn annoying. So that might be the person who's calling every 3 minutes. Okay, that's harassment. They were sending 1 million emails. Harassment. Okay. Now worth noting, this has got a higher threshold than any of the other sections, and it requires that there is a significant likelihood of serious harassment. So someone who's not had a history of harassing other people, you would be very hard pushed to argue they're going to have a significant likelihood of starting to harass someone the minute you release it. However, if you have released stuff to them before, or they've had to be warned by your organization about harassing the staff, then maybe you could argue that there is significant likelihood. Okay. And that's what we're saying. You will get individuals who make routine privacy requests. Okay. And that is their right. They're entitled to it. If they keep making the same request, because we commonly say this, all information about me, it is okay to go back and say, as we told you on this date, here is a copy of that information on this date, and here is the delta in between. That is okay. You don't need to recollate it all unless you are thinking there's something different in the middle. Okay. And then the other common one we get, we can't actually find it, or it isn't here. Okay. Now, in terms of this one, we need to make reasonable efforts to go forth and search for it. Okay. So that means that we didn't just do an IT scan and go, yep, not here. Okay. We need to have actually gone and had a look for it, etc. So that might mean that we need to, if it's paper records, go to the records room and actually have a look. Is it in the box labeled S if my surname begins with S? No, it's not. Cool. I made reasonable efforts to look for it in the box. There isn't an expectation that I look for it in every one of our million boxes because I think it could be here somewhere, maybe. Okay. So reasonable. And again, you need to be able to explain your reasonableness if queried. So this is where we might make notes that says, I've looked here, I looked there, it is not in these places, I've requested this person, they don't have it, etc. Okay, we need to be able to demonstrate it for that one. Now, a couple of other ones we occasionally see. I want to redact it because it is evaluative material. So evaluative material is a very strict definition in the Privacy Act. So if you think this is going to be you, do check the definition. And it's predominantly about employment. So it is about stuff about, should I hire you for this job? Should I give you a mortgage? Those sort of evaluative material. And it is only about the section of the information that is evaluative. So it's not blanket everything. It is just about the bit that is evaluative. But I would get advice for that. Some other ones might be, it's actually going to be a breach of legal privilege to release it. Yet again, don't do that. It's not going to end well. So what happens once I have released it? So when I release it, I send it to the individual and I send a letter or an email that says, please find a copy, attach the information you asked for, and we have redacted certain bits on the following grounds. And it's clear to me which bits on which grounds. So it might have a box over it in black that says I redacted this on the grounds that I think you're going to harass me, this sentence. Okay, it's not the whole document, it's the particular pertinent parts of it. Or, hey up, here's a full copy of it. On that email, we need to explain to people they have a right to complain to the Privacy Commissioner as well about our request. Okay, so if they don't like the answer, they can go forth and complain to the Privacy Commissioner. Now, the most common complaint to the Privacy Commissioner about these sorts of things is usually they didn't give me everything they've got, or they redacted way too much. So let's start with the first one. They didn't give me everything they've got. It is super common when you request all information about yourself that an organization only looks in their customer management systems, so CRM, and they literally look there and that's it. So they might give me my notes about my account I hold with them, but no emails, no phone calls, no anything else in the mix. Okay. And then the person will be like, actually, I wanted that particular thing that you haven't supplied me. The other ground is that they want to contest the redactions. So the Privacy Commissioner got new powers in 2020 to issue what's called an access order. So in this case, if they complain, hey, you've redacted way too much, and the individual thinks that is the case, then they will complain to the Privacy Commissioner. Privacy Commissioner will ask you to supply a copy of your unredacted version and your redacted version. And at that point, they will look at it and see if they can justify your redactions. Usually they will come back and try and negotiate with you about not being quite right. But if there is a stalemate, the Privacy Commissioner can issue a binding access order. So this is where the Commissioner says, you will release that redacted sentence. I have decided, go forth and do it. Okay. So in effect, the Privacy Commissioner has become the lawmaker on it, or the rule maker, and he has the final decision on whether you're going to redact it or not. So this is really important when we think about redactions. Because if we are trying to build transparency and we send someone a document with a million redactions in it, they're going to think there's a cover-up, okay? And they're going to want to know what's under the redaction, and they're most likely going to get more upset because you redacted something. So we need to think about how we use them sparingly so that we aren't leading ourselves down that path, but we're also looking after the interests of our organisation and our other staff, etc. The most complicated ones that usually come are actually from staff members themselves, okay? Because bear in mind, any individual can make a request for a copy of the information you hold about them. So that could be that staff member who has asked for a copy of everything about them that you hold. Now, they might just want their HR file, they might want their performance report for last quarter, or they might want, as I mentioned earlier, every email they've ever sent since being at work. Usually staff ones come about around the time of restructures or redundancies. And the reason for that is there's often a belief of a cover-up, and they want all emails that led to that decision about what's going to happen at that point. Okay. In terms of some of the more complex ones you get, some of the weird ones that you might get, I have seen requests for all my web browsing history on your website. I have seen someone who has asked for footage of themselves sitting on the train every day in a month, just so they could check out how they looked. And as I say, if you are that government agency who is getting one of those, so trains, for example, are usually run by the council, so they can't charge for them unless they get specific permission from the Privacy Commissioner, think about what you did to that person. I am damn sure that individual did not want a copy of themselves sitting on the train. Okay, exciting as that would have been. So think about asking the question, is there something else I can help you with? Because if there is, I bet you anything, if you resolve their initial problem that's not privacy related, most probably you can close out their privacy request and they'll be like, oh, yep, don't need that information anymore. Okay, so if it is very large and cumbersome, do just think about, has it been done as I won't say retaliation, but in response to a complaint about something else, because that's usually your cause of it. So that is all I have to talk about. Any questions on dealing with these, pop them in the Q&A and we will be able to have a look and see what else we have got.